Con Law 2024, let's talk 14th Amendment and substantive and procedural due process. All right, first of all, what does equal protection have to do with due process? You know the answer. Nothing. Equal protection applies when the government is treating different classes of people differently, whereas due process, we have substantive, which is concerned with actual rights that are impaired and whether the government has the authority to impair that right, and procedural due process, meaning the fairness and adequacy of procedure. Okay, before we start out, let's talk about the void for vagueness doctrine. Okay, so a law is void for vagueness if it doesn't give an average person fair notice of the prescribed conduct, and it is so lacking in standards that it is ripe for discriminatory enforcement. Void for vagueness, no fair notice, and it's lacking in standards. Void for vagueness. A law is void for vagueness if it doesn't give an average person what? That's right, fair notice of what is prohibited. And it is so lacking in what? Standards, that it is, yes, ripe for discriminatory enforcement. All right. Void for vagueness, no fair notice, and it's lacking in standards. No fair notice, and it is lacking in standards. That is void for vagueness. So any law is void for vagueness if it does not give an average person what? Fair notice, and it is so lacking in standards that it is what? Ripe for discriminatory enforcement. And by the way, what does equal protection have to do with due process? Nothing. On the MBE, they will ask you about equal protection or due process, never both. Remember, equal protection applies when the government treats what? That's right, different classes of people differently, whereas due process is concerned with the actual right that is impaired and whether the government has the authority to impair that right. And of course, procedural due process is fairness and adequacy of procedure. Let's get started with substantive due process. Our substantive due process has two prongs. One, does the law burden a fundamental right? Two, the law doesn't burden a fundamental right. Easy. Okay. Prong one, does the law burden a fundamental right? We apply, guess what level of scrutiny? That's right, strict scrutiny. Who is the burden on? That's right, the government, to show what? That the law is narrowly tailored to a compelling governmental interest. If a law burdens a fundamental right, the burden is on who? That's right, the government, to show what? That the law is narrowly tailored to further a compelling governmental interest. This is why a law that burdens a fundamental right will rarely be upheld. So that's prong one, burdens a fundamental right, strict scrutiny. Not fundamental right, rational basis review. Burden is on who? That's right, the challenger, to show that it is not rationally related to a legitimate government interest. This is a very deferential standard. This means that laws that don't burden fundamental rights are rarely overruled and they're usually upheld. Why are we not talking about intermediate scrutiny here? That's right, because we are doing a substantive due process analysis. We are only concerned about whether it's a fundamental right or not a fundamental right. If it's a fundamental right, we're going to apply strict scrutiny. If it's not a fundamental right, we're going to apply rational basis review. Okay, so fundamental rights are those that are one, implicit in our scheme of ordered liberty, and two, deeply rooted in our nation's history and tradition. Okay, Dobbs made that very clear. A fundamental right is one, implicit in our scheme of what? ordered liberty, and 2, deeply, that's right, rooted in our nation's, that's right, history and tradition. Okay, try to repeat the whole rule. A fundamental right is 1, that's right, implicit in our scheme of ordered liberty, and 2, deeply rooted in our nation's history and tradition. So what are these fundamental rights? There are 10. 1, care, custody, and control of one's children, the right to raise your children without state interference. Care, custody, and control of one's children without state interference. And our classic cases here are Meyer versus Nebraska, Troxel versus Granville, and Pierce versus the Society of Sisters. Family life and cohabitation with members of your household. Our classic case here, Moore versus the City of East Cleveland. The right to contraception, you know it, Griswold versus Connecticut. The right to marry, Loving versus Virginia, Obergefell versus Hodges. The right to procreate, Skinner versus Oklahoma. You cannot sterilize an adult without their consent. The right to consensual adult sexual intimacy, Lawrence versus Texas. Okay, those were easy, an easy 6 rights. Kids, 1 is children, 2 is cohabitation with your household, 3 is contraception, 4 is marriage, 5 is procreate, 6 is sex. Okay, 1 is children, 2 is, that's right, family life, 3 is contraception, 4 is marriage, 5 is procreation, and 6 is sex. All right, so those are all concerned with kids, sex, family life, marriage, and having kids or trying not to have kids. Okay, finally, number 7 is the right to vote. Remember, the right to vote is fundamental, and therefore it is subject to strict scrutiny. There are a few pointers under the right to vote. Under the 15th Amendment, the right to vote may not be denied based on what? That's right, race. Under the 19th Amendment, the right to vote may not be denied based on, that's right, gender. And under the 24th Amendment, no poll taxes. Poll taxes are unconstitutional under the 24th Amendment. Okay, so let's talk about some things that burden the right to vote, but are not subject to strict scrutiny. Okay, so remember, the right to vote is fundamental. Under the 15th, you can't deny a person to vote based on race. 19th, you can't deny a person the right to vote based on their gender. 24th, you cannot impose a poll tax. But there are some things you can do. For example, we all know that felons may be permanently denied the right to vote. But what about redistricting? Okay, we've come upon that, voting district, gerrymandering, etc. That's a political question. We've come upon that in constitutional law before. But did you know that the one person, one vote idea is not in the Constitution? What is the standard? A voting district must be fairly apportioned based on population. Fairly apportioned based on population. Okay, so can you redistrict based on race? No. Can you redistrict based on population changes? Yes. Districts must be what? That's right, fairly apportioned based on what? Population. Okay, there can also be regulations or restrictions on voting. For example, durational residency requirements, okay if they're short, Marston versus Lewis. Making it more difficult to vote. Does it place an undue burden on voting? Remember, burden versus the benefit. So there was that case in which in Indiana required that someone had to have a valid photo ID. That was fine and constitutional because it didn't make it impossible for people to vote. It just made it more difficult. Or how about being a candidate for political office? Residencies, filing fees. So all that is subject to rational basis review. Okay, so let's go through our first 6 again. Number 1, children. Care, custody, and control of one's children without state interference. And what are our cases? Pierce versus the Society of Sisters, Meyer versus Nebraska, Troxel versus Granville. Number 2, family life, being able to live with members of your family. What's our case? That's right, Moore versus the City of East Cleveland. Right to contraception. What's our case? That's right, Griswold versus Connecticut. How about the right to marry? How about the right to procreate? Our case is Skinner versus Oklahoma. Consensual adult sex. That's Lawrence versus Texas. And the right to vote. So under the 15th Amendment, we have no racial discrimination. Under the 19th, we have no gender discrimination. And under the 24th Amendment, we have no, that's right, poll taxes. But we have some restrictions on voting that are okay. Districts are not one person, one vote. What are they? They are fairly apportioned based on what? Population. You can regulate the process of voting, balancing the burden versus the benefit of, say, obtaining a photo ID. You can also have reasonable durational residency requirements. In our case, there is Marston versus Lewis. So that's number 7, our right to vote. Okay, couple of other things that we want to cover under right to vote. Remember, one person, one vote doesn't apply. And it especially doesn't apply to special or limited purpose voting districts, and specifically water storage districts. It's also generally invalid to restrict voting based on property ownership, although there are some exceptions. Okay, that's it for voting. That was a big one, the right to vote. Okay, regulations of process making it more difficult to vote. What test do we use? That's right, balance the burden and the benefit. In other words, our classic undue burden test. And a district must be how apportioned? That's right, fairly apportioned based on what? That's right, population. And how about durational residency requirements? They're okay if they're short, 50 days, Marston versus Lewis. Can you restrict the right to vote based on land ownership? No, that's generally invalid unless it is a special or limited purpose voting district. One person, one vote doesn't apply specifically to what kind of voting district? Water storage districts, where the water is limited to landowners. Okay, we have 3 more fundamental rights. The right to interstate travel. So that's guaranteed under what clause? That's right, the Privileges and Immunities Clause. 9, the right to refuse medical treatment. And 10, all right, we know that there's no fundamental right to abortion because it is not deeply rooted in our nation's history or tradition and implicit in our scheme of ordered liberty, right? So under Dobbs, abortion was given back to the states. So state laws restricting abortion are subject to rational basis review. Remember, if it's a fundamental right, we get strict scrutiny. If it's not a fundamental right, rational basis review. Okay, so let's go through our 10 rights, fundamental rights. 1, that's right, care, custody, and control of one's children. 2, cohabitation with your family. 3, contraception. 4, the right to marry. 5, the right to procreate. 6, the right to adult sex. 7, the right to vote. 8, the right to interstate travel. 9, the right to refuse medical treatment. And 10, abortion, no fundamental right anymore. Rational-based review applies to any state law restricting abortion. Okay, so there are other rights, which are generally called our economic rights. So the right to seek work, the right to welfare benefits, the right to, say, your tax refund, and oddly enough, the right to loiter or panhandle. Okay, so that's substantive due process. Does the law burden the fundamental right? Strict scrutiny. So that type of law is rarely upheld. If it's not a fundamental right, rational basis review to show the law is not rationally related to a legitimate government interest, and this is rarely overruled, very deferential to the government. And fundamental rights are, 1, implicit in, that's right, our scheme of ordered liberty, and 2, deeply rooted in our nation's history and tradition. And there are 10 of them. 1 is, that's right, care, custody, and control of one's children. 2 is living with your family. 3 is contraception. 4 is marriage. 5 is procreation. 6 is consensual adult sex. 7 is right to vote. 8 is interstate travel. 9 is right to refuse medical treatment. And 10 is no fundamental right to abortion. And our other economic rights, welfare, right to loiter, seek work, practice one's trade, get a tax refund. All right, that is substantive due process. Okay, next up is procedural due process.